medical malpractice actions, you'll see from his CV that he has a particular interest in the defense of obstetrical claims. Tom?
I won't be offended as people flood to the exits for the damages section. This is where I should be. Great. Sorry that I haven't been here earlier. I enjoyed that last session. Although it lacks very much drama, the issue of damages in these kinds of cases, no matter which professional you're speaking of suing or defending, is, in my experience, very important. And the reason that it has special significance is because it is often the undoing of the claim, either to the dissatisfaction of the plaintiff or to the delight of the defendant. And it really hinges, in my experience, on the relationship between damages which are thought to be suffered and or lack of relationship between those damages claimed and the issues of negligence or breach of duty which are established by the plaintiff. It's almost invariable that there is some error or omission or breach of duty even which has brought a plaintiff to see counsel, to sue a professional advisor. Something bad has happened, whether it's a physician and they've got a terrible complication, or it's a lawyer and something bad happened in a business transaction. There's usually some basis, something has happened. And often that is enough for people to believe that they should obtain some redress, and they launch a claim. And the reason that the question of damages and the question especially of causation of harm is so important is because if those issues aren't addressed at the beginning, when you're assessing the issues of breach of duty and the questions of liability, often the action unfolds and goes along very nicely until either at a pretrial or worst yet at a trial, the wheels come off because there isn't any relationship between the act of negligence and the damages thought to be suffered. And it's an evolving area in the professions. So I thought I would spend a bit of time, the paper discusses these issues generally, but I thought I would spend the time this afternoon talking about the things which I think those suing and those defending should assess early on in these kinds of cases. And it really doesn't matter, in my experience, whether what kind of a professional it is, or even really what the cause of action is, because as you know, there are a bunch of different causes of action against a bunch of different professionals, but they all really unfold the same way in respect of the damages and in respect especially of the issues of causation. So as quickly as you assess the liability issue and understand what the breach of duty is, in my opinion, you should consider the cause of action or causes of action which your client, for the plaintiff, have available. And they generally are going to fall into one of the three big categories of negligence, or negligent misrepresentation commonly in cases against advisors, or breach of contract or a retainer agreement, that sort of thing, or most commonly now a multitude, including breaches of fiduciary duty. And it is the breaches of fiduciary duty which have attracted most of the attention recently, and which raise interesting questions of causation and proof of loss. There are many cases in which the courts seem to have, in cases of breach of fiduciary duty, really dispensed with any consideration of the causal link between the breach and the loss, and the plaintiff drives from the liability to collect the damages. And I think that proper consideration of those cases from the defendant's side reveals that, in fact, there are many defenses which arise even in the cases of breach of fiduciary duty. Now, what should you do? In my view, you should, having assessed the cause of action, break down the elements of the of the proof of causation, and with the client early on for the plaintiff, understand what it is that they have suffered and may continue to suffer. Because, again, in my experience, I've seen many cases go off the rails on account of the plaintiff's failure to mitigate, whole failure to mitigate. They establish the loss early on, and it mounts. But at the end of the day, the court says, well, you had no business really standing by while these damages built up. You had an obligation to sell the land you say you didn't want to have, or the shares, or whatever it is. And it's an issue which I think bears special attention. Just a moment on the cause of action question. If the claim is a claim for breach of fiduciary duty, and bear in mind that there is a real controversy, and there's a very interesting decision the BC Court of Appeal decided in November, which invites the Supreme Court of Canada to consider this issue again, a case called C.A. and Critchley, in which the BC Court of Appeal concludes that there is no remedy for, or shouldn't be any remedy for, a breach of fiduciary duty where an employee of the Crown committed a wrongful act. And they decide that really the breaches of fiduciary duty should be confined to cases of the traditional breach of fiduciary duty type, and not be expanded in the way the Supreme Court of Canada has. And the Chief Justice of the BC Court of Appeal spends a lot of time analyzing and criticizing the Supreme Court of Canada's decisions. So, but remember that on the good side, they're certainly still alive and well. And in a case like Hodgkinson and Sims, where a financial advisor failed to disclose a conflict, in effect, the tort claim failed. The breach of fiduciary duty claim succeeds because he hasn't disclosed the material fact, but actually there was nothing wrong, according to the court, with the financial advice he gave. On its merits, it was okay advice. It turned out to be lousy in the sense that the plaintiff lost on the investments, but there was nothing negligent about the advice. So in the absence of a claim for breach of fiduciary duty, the plaintiff in Hodgkinson would have been out of luck. So it's essential, I think, that you assess what the plaintiff has or doesn't have, bearing in mind that the courts are really rolling back the fiduciary duty issue, and there have been many cases which criticize plaintiffs for calling straight negligence claims breaches of fiduciary duty. Having sorted out what the cause of action is, way before you have an expert or anything else, it seems to me that it's possible to define the categories of losses which the plaintiff is or is not entitled to. And often at that stage, you can know for the plaintiff, or for the defendant for that matter, whether this is a large claim or a small claim, and whether it's going to justify running the thing through to the process of having expert opinions and so on. And oftentimes these things just aren't worth very much. There's a case that is referred to in the paper called Palmieri and DePoche, in which the Court of Appeal this past year reduced dramatically an award of damages that a trial judge had made on account of his failure to reject elements of the plaintiff's damage claim as being completely unrelated to what the plaintiff had established was the act of negligence. And the plaintiff's theory, from the very beginning of the case, was wrong-headed because it didn't consider what the cause of action would have entitled them to claim. It's interesting, too, because it stands for the propositions of their failure to mitigate the damages, and in particular to pay judgments which had accumulated on property which they said they didn't want to buy. The solicitor's negligence caused them to close a transaction which they said they didn't want, and they allowed losses to mount, didn't pay creditors, and therefore just allowed interest rates to run on judgments and so on. The court said you can't do that. You've really got to, from the first minute that you understand that you have a claim, you've got a responsibility to mitigate your damages. The Court of Appeal in that decision also deals with issues of remoteness, which aren't often found in cases of professional liability, but for the defendant, don't forget that not all of the damages claimed by the plaintiff will be recoverable if they fall outside of the usual tests for the limitation of remoteness. The other thing which I think is worth considering at the very beginning is who is the plaintiff? Who's the proper plaintiff? That case I just referred to, Palmieri, is an example also of that. The plaintiff had assigned her interest in the land and the building to two other entities, one an individual in trust, the other a corporation. The plaintiff, though, was the plaintiff at the trial until about the middle of it. They recognized the problem and amended to include the proper plaintiffs. But there are other examples of that in the cases, and it's essential that you assess, particularly in business cases where there are trusts or partnerships or corporations, who actually suffered the loss, forgetting who had the relationship with the professional, because it's often, in those cases, 2 or 3 different entities. So a couple of things about causation. The plaintiff bears the onus to establish the relationship between the breach of duty and the loss. And as I indicated, often it's only after spending an enormous amount of time proving the breach of duty that people turn their attention to what actually occurred. It's the sort of so what thing for the defendant. I always ask myself, so what if all of these things in the statement of claim are true? What then? What happened as a result? Many times the plaintiff is really unable to establish that anything would have been different. And there are many cases and decisions in this, especially in this province, where the claim really fails on that important ground. And it's not to say that the plaintiff hasn't established got through the first gate of breach of duty, but there must be some relationship between an act of negligence and what the plaintiff then did or didn't do, and which caused some monetary or other loss. And there are many examples. There are many examples of solicitors in real estate cases making some omission which ultimately didn't really affect the plaintiff because there was no other option. It's true especially in cases against physicians where the plaintiff may well establish before the operation the physician didn't advise me that there was a risk of X. But again, it's so what, because the plaintiff must then establish that that he or she would not have had the procedure had those things been disclosed. And many times in those cases, for the defendant, one focuses on what it is that the plaintiff was doing before the operation. Why did the plaintiff need the operation? Many times it's the end of the road. There are no other treatments that are going to work, and they really have no choice but to take the procedure, no matter what the risks are. And again, many decisions have gone against the plaintiff on that ground. The same principle is true in cases against financial advisors, solicitors, other professionals, because invariably for the defendant, one will want to look at all of the circumstances of the plaintiff who says, well, I really wouldn't have closed that transaction if I had known about this or that. An examination of their circumstances reveals that they really had no other choice. Or at least the other choices weren't going to be any better. In the case of Mr. Hodgkinson, a defense that failed, although it has succeeded in other cases in British Columbia, is that if you didn't invest in this MERB and suffered all of the losses, you would have invested in that MERB, and when the real estate market crashed, suffered all the same losses. And it's those things which, in my view, one has to consider on both sides to figure out whether anything bad happened to the plaintiff as a consequence of the professional's breach of duty. In cases against solicitors and those involving fiduciary duties, there are interesting cases in Ontario which reverse the onus, as I'm sure you've seen. Commerce Capital and Burke is the clearest, where the plaintiff, having established the breach of fiduciary duty, say in that case a failure to disclose material facts, the onus then shifts to the defendant to establish on a balance of probabilities that notwithstanding that failure to disclose the material facts, the plaintiff would have gone ahead with the transaction. Invariably, the plaintiff comes to testify to say, well, I wouldn't have proceeded. And just as in the cases of informed consent in medical negligence cases, the court has to have a very careful look at that evidence. It's purely self-serving. But nonetheless, it is open to the defendant, although difficult, to establish that the plaintiff would have gone ahead with the transaction in whatever it is. And there are cases in our Court of Appeal recently where those findings have been made and upheld. A case from London called Canada Trust. Commerce Capital goes the other way. The Court of Appeal concludes that on balance, the trial judge was wrong to conclude that the plaintiff would have gone ahead even if the material fact was disclosed. So for both the plaintiff and the defendant, an early assessment of that causal question should throw out to your attention the factual issues which are going to control it. And invariably they are the circumstances in which the plaintiff finds itself or herself or himself in at the time of the breach of duty alleged. The proof of damages flows, as I indicated, from the cause of action. There are a couple of cases in the Court of Appeal which have really clarified this area of law. Many cases against professionals involve real estate, and the Toronto Leasehold Improvements case has established now a very clear formula for the calculation of those damages. In those cases, therefore, it's important to get an early quantification, not to the dollar, but rather of the type of damages which your client is going to be entitled to. It's going to be the difference in the property value. It's going to be the loss of the opportunity to invest the difference, and it's going to be consequential losses. Many cases are not worth that much money when one makes that measurement, even as a rough and ready guide at the start. On the other hand, the opposite is also true, but it's important if you're going to, whether you're advising the plaintiff or defendant or considering the issue of expert evidence, to guide those parties with those principles that flow from those cases. And invariably you will find that the cases are clear as to the measure of damages according to the cause of action you're asserting and the issue underlying it, whether it's the sale of land or shares or some other loss. A word or two about experts. And the panel had, Marty Teplitsky spoke about the usefulness or not of appraisers. You're always faced with the question of in my experience, two aspects of proving damages. One is to make sure that you get early on control, for the plaintiff at least, control over the witnesses and the documents which prove the factual basis of the loss. In cases of business losses and so on, you'll need to track down invoices and controllers and all of those people, and make sure that you can establish, if you have to prove them, each and every element of the loss, all of the expenses, all of the other liabilities. Those things have to be provided, of course, to the expert once you've gone far enough down the road to allow the damages to be quantified by an expert. And I always make it a practice of providing the expert with every single thing which he or she will need to make, not only to make the calculation, but also to present the evidence in court at the trial. And of course, that's a fruitful area of cross-examination of experts in this area. What have you considered? What have you not considered? Because having regard to what the legal principles are, there should be a kind of narrow division between the experts as to what it is that they are quarreling about. And if they have gone off on a tangent one way or the other, it's often because they have either not considered the correct approach, the correct legal approach, or else they've made assumptions which are not supported by the evidence. Either they have not read the expert opinion on the other side, always give them that. They haven't read the examinations for discovery, so they don't know what actually happened with Mr. Jones after the real estate was purchased or not, and all the way through. So it's essential that you get them all of the information which they're going to need, and that you guide them as to the legal framework into which they should be making their opinion. Some of these experts are skilled enough in this area to know what they're doing and may not need so much guidance. But I make it a practice either of, if there's a case like in this Toronto leasehold case, which very clearly defines what the scope of the remedy is, give them the case, or give them a summary of the case. Set it out in 1 or 2 pages so that they know what they should be calculating. Otherwise, they'll go off track, they'll cost you a lot of money, and they won't be of any use to the trial judge. A couple of other things, if I can. It's important to consider on both sides again the questions which derogate from the damages, issues of mitigation, including now issues of tax benefits received by the plaintiff after some negligent act or breach of duty has been suffered. The cases are clear that in some cases you will be able, for the defendant, to get the benefit of the tax position that the plaintiff took if the plaintiff has reduced his or her or its loss as a consequence of its tax position. There are cases of going both ways on that issue, but they turn on whatever the peculiar facts are. But in Hodgkinson, for instance, Mr. Hodgkinson was able to offset losses of other income, or not losses, rather. He took his losses from the investment at issue and reduced his liability to Revenue Canada. Defendant doesn't pay on the gross amount, but rather on the net amount. So it's important to do that kind of spade work for the defendant in order to get that information at the examination for discovery or otherwise. I've touched on remoteness. There are a couple of cases which deal with contributory negligence or intervening acts. Often in the case of financial advisors, your client, for the defendant, won't be the only person giving advice. And it may be worthwhile to consider third-party claims or other defenses that might assert those kinds of things. There are a couple of cases which have found plaintiffs contributorily negligent for failure to look after their own financial affairs or failure to pay attention to the lawyer's advice. The case I refer to in the paper is one in a real estate situation in which the plaintiff failed to attend at a closing in a timely way and put the defendant's solicitor in a difficult position. The court said that that amounted to a 25% reduction in the damages that the defendant would otherwise be responsible for. Those are rare cases, but you should, for the defense especially, analyze those questions carefully in assessing what the plaintiff did after the breach of duty and before. May I just leave you with a couple of other things to bear in mind. There are rare cases involving counsel, but one of the interesting ones is this decision of Madam Justice Greer in a case called Boudreau, in which the plaintiff was convicted of a criminal offense and claimed against his counsel that counsel didn't interview the witnesses, bullied him into pleading guilty, and so on. Now, ordinarily, one would have thought that kind of question should be determined by whether or not the defendant was or wasn't guilty of the offense. In this decision, Madam Justice Greer says it doesn't matter. It's irrelevant whether he was or wasn't guilty of the offense. And she awards him $30,000 for mental distress and a couple of other amounts in special damages, including, and never forget this if you're suing solicitors, I must say, the costs, every dollar of the amount paid to the defendant's solicitor or counsel in the criminal case. And there are a couple of cases going both ways, but it's certainly a consequential loss that you should be considering. The other case which is really important to review for everybody doing this work is the decision in Martin and Goldfarb, which the Court of Appeal just dealt with this past year, and in which they reduced a huge award against a solicitor which had been awarded by the trial judge for breach of fiduciary duty. And what Justice Finlayson for the court says, there were really three issues on appeal. One, did the trial judge properly consider the causal relationship between the breach of fiduciary duty in issue and the damages claimed by Mr. Martin? And Mr. Martin had asserted a huge loss on account of a bunch of investments that he had made and lost money in because the defendant's solicitor was in breach of his fiduciary duty for not telling him that his business partner was a convicted felon. And really, the trial judge ran up the award of damages considering every loss that Martin had suffered. The Court of Appeal says that is the wrong approach, and that what is required is a close examination of the relationship between the losses suffered by Martin and the breach of fiduciary duty. Don't just because you have a claim for breach of fiduciary duty assume that you get dollar for dollar everything that you've lost. The second thing they consider on the issue of damages is who is the proper plaintiff, Martin or his corporations, and the court answers that question by finding that only Martin personally had suffered the losses. But the final thing is really an important point, and it amounts really to a criticism of the plaintiff for the manner in which they led the case at trial and the manner in which they attempted to prove the damages. And it is a long critique of what should or shouldn't have been done by counsel and the plaintiff in leading these kinds of issues. In other words, if you have a big, complicated damage claim, there is a way to do it to establish not only the causal link, but who suffered the loss, when they suffered the loss, in what amount, and what the legal basis is for the claim. Instead, in that case, the Court of Appeal says that the plaintiff really just came to court with a bunch of figures and without much assistance dumped them on the trial judge. And the trial judge added them up and they came to $10 million. The Court of Appeal referred it back and said, wrong approach, do that over again on a proper evidentiary record. But it really is important to read that decision to figure out what should or shouldn't be done. How are we doing for time? Over.
You can have another couple minutes if you like.
Yeah. We'll get on with the panel. Thank you. Sure.
A question?
Just your comments, my basic, your comments about including the dollars paid to solicitors as damages, you say?
Well, there are some cases that, and this is one of them, this Boudreaux case, and there are other cases in which the court has awarded as a part of the consequential loss suffered by the plaintiff the amount they've paid the solicitors. There are cases going the other way which say, and it makes sense to me, that you would have had to pay a lawyer in any event. You may not have got a great job, but that's why you're getting your damage claim. You can't also get out of the legal fees. But those are the competing theories. Boudreaux goes the one way, and there are a couple of cases that go the other.
Thank you very much, Tom. Let me introduce briefly the members of our final panel. Cynthia Amsterdam will be chairing the panel. Cynthia is a partner at Genet Murray who does a good deal of work on behalf of accountants, both in the liability and discipline fields. Peter Downard from Vaskins is also here. Peter has a particular interest in proportionate liability, which I think you'll be talking about. And finally, the Honorable Joseph O'Brien, QC. He's now one for Majesty's Counsel again. When I called Justice O'Brien, as he then was, to ask him to participate in the panel, he said that he was retiring from the bench at the end of that week and that we might not want him as a result. But then when we determined he was going to be at ADR Chambers thereafter, we both agreed that it would be a good idea that he be here. Cynthia?
Thank you, Gavin. Well, Tom had an opportunity to touch on just sort of the highlights of his paper, and what we as a panel are going to try and do is just discuss with you some other issues that sort of flow from this whole area of the case, which, as Tom was trying to point out, is really, in essence, one aspect of the case that oftentimes gets left to the end and should, in essence, be examined very, very quickly up front. And in using Hodgkinson as an example, Tom, you were talking about how in that case the tort part of the claim did not succeed. Good that they had the fiduciary end of the claim involved. So one of the things that counsel, as plaintiff's counsel, should be looking at is, in suing a professional for a breach, what's in fact the best strategy in terms of how you would frame a case, and is it necessary in all instances to gratuitously throw in the breach of fiduciary duty to make sure you've covered all your bases.
Well, there's really two schools of thought about this. I'm sure you've read the decision of Madam Justice Southern in the when she was on the trial division in British Columbia in a case called Gira Debt, I think, or something. But it's quoted all over the place. And in it, she leads off this decision, which is about a straight claim of solicitor's negligence, by saying that lawyers fling the fiduciary duty claim around like it applies to everything, and really it only applies to certain causes of action. So ideally, I think those words of hers should be paid attention to, and that we really should be considering claims of fiduciary duty as different from claims of which lie in negligence or some other cause of action. But I'm afraid that now people become very skittish about confining themselves to one thing or another. And in this case of Martin and Goldfarb, Finlayson JA reviews the procedural history and describes that the breach of fiduciary duty claim was only added about a year or so before the trial, and it had gone on and on and on before. So it's always a difficult question. I don't know whether you're wise at the very beginning to confine yourself to something other than fiduciary duty if there's any uncertainty about it.
One of the cases that Tom and I had the benefit of being co-defense counsel for different clients on did involve a situation where an accountant who was a managing partner of a large accounting firm had, in the process of retiring from the accounting firm, gone into business and essentially purchased land on behalf of the clients, in essence, and then took out mortgages from the clients. The property then subsequently lost a tremendous amount of value, and the clients, being extremely sophisticated real estate entrepreneurs, then sue the accountant and then the accounting firm in the process, as well as their lawyer, claiming that everybody were fiduciaries. The accounting firm was vicariously liable, and that the solicitor breached the duties in terms of how the transaction was held on closing and what security was not sufficiently, allegedly not sufficiently put into place. And one of the aspects of the accountant's position, which was also part of what the accounting firm did, was argue that there was not a position of a fiduciary in existence as between these very sophisticated investors vis-a-vis the accountant. And at pretrial, the court, at that point, it was I thought, a very good pretrial that we had. We had a good vetting of all of the issues, and the court was indicating that if the matter had to go to trial, that perhaps the plaintiffs would have a very, very difficult time in establishing fiduciary duty on behalf of the accountant and the accounting firm. So we dropped out of the case midway through. Tom had the benefit of being there further on down the line. I don't actually ultimately know how what ultimate head of damages was decided upon. I don't know whether...
We lost, so I can't remember either. I've suppressed the memory of that case.
But the fact is that in that case, there was allegations of breaches of contract and negligence as well. And so at the end of the day, that was an example of a case where plaintiff's counsel had decided that they would cover all of the bases and pursue each avenue, and as well throw in as many professionals on the defense side of things as possible. From the bench, Mr. O'Brien now, as opposed to the Honorable Mr. O'Brien, can you give us some view on how you feel sometimes in professional liability actions that there is a good use or perhaps a misuse of expert evidence in the way that plaintiff's counsel or defense counsel leads the evidence to establish their position on damages?
Thanks, Cynthia. Before I do that, I look out here and I see that we're down to a lot of the hardcore attendees, which is very nice to see. But it reminds me of the time I was in the bar admission course and I was trying to jazz up the program one year, so I called Buddy Wonder down from London, or at least from Windsor, to entertain the group here. And there were a whole bunch of kids, and one of them got out and left. And Buddy stopped right in the middle of what he was saying, and he said, don't go, don't go. He said, I get better. You come on, sit. When you see a hardcore group of attendees, I'm always reminded of Buddy Wonder and his story. But I digress. The use of expert evidence is a really interesting point now with a lot of judges, because a lot of judges, and I think I was becoming one of them, tend to become rather cynical. They see a great overuse of expert evidence, particularly at trial, often a great waste of time and money, and it's very difficult for a trial judge in many of those cases to say, I'm not going to let that expert testify, because your concern is, particularly on a long trial, if you make the wrong choice, perhaps the thing goes to the Court of Appeal, and while you're not worried about being reversed by the Court of Appeal yourself, you are concerned that that case is going to be sent back for a new trial because you were wrong on excluding the evidence of the experts. More judges now, I think, are taking the view they're going to take that risk. And I commend to you, if you get involved in this, an excellent paper that Niels Ortved delivered on the damage program, which was given by the Law Society in June of '98, in which he goes into a lot of the relevant cases dealing with the use and misuse of expert evidence, and a decision of Justice Sapinka in the Mohan case, in which they carefully take a look at what should be done. And I commend that article in those cases to you, because if you're going to get involved in some of these cases, I think you'll find more and more now that the use and misuse of experts is going to be challenged by your opponents, and you're going to find, I think, quite a few trial judges who are going to accept that. A recent decision of Justice Farley in the Schneider case, in which there were a lot of evidence being given on business valuations and matters of that kind, and he took a bit of a scunner to that kind of approach, and as I recall the case, concluded that there should be 3 experts per issue, and he restricted them quite severely in that area. So this is an area that I think a lot of counsel should think about. Cynthia's question at one point was, how do you weigh the evidence of experts when there are conflicting conclusions? And that ties in nicely, I think, with what Justice Gans told you in his lecture. You've got to take a look at the analysis that's made by the experts where there are conflicting reports. You tend to look at see what other evidence there is to support the various premises and theories. One of the things that Justice Gans pointed out, which I think was an excellent one, was that you often have experts on paper who look almost identical. But when you get the 2 of them in a witness box, you'll find that one witness may be of the kind that Justice Gans is talking about, where he's arrogant, he's condescending, he's refusing to make simple admissions or any kind of concessions, and he very quickly comes across as a hired gun. And Justice Gans suggested to you that before you call some of these experts, you should sit down and make that kind of analysis of how the witness is going to impress a court. And I do tell you that that is a very significant part of it, because as a trial judge, you often had a feeling after a trial that the witness who looked good on paper just didn't stand up because of his demeanor and his general approach. And finally, there are a lot of hidden persuaders, and the judges get to know who the hired guns are. They know who they are, and if you're involved in a case with some of these witnesses who, with great respect to them, really become hired guns, the judges know that and back away from some of those. Finally, as a mediator, I've seen a number of cases now where rather than an overuse of expert evidence, there seems to be an underuse of it. And you have to bear in mind that on a mediation, unlike a trial, you're trying to persuade the opposite side, usually an insurance adjuster or a company representative who's there on behalf of the company, who's going to make decisions on that mediation and authorize payment of cutting a check right then and there. And unless those people are persuaded that there's a substantial damage claim to be paid, they won't do it. And too often on mediations, I'm finding now that there aren't enough expert reports and information that persuade the decision makers on the other side to come up with the money that should be at that stage. So you've got the dichotomy between too much on one hand and perhaps not enough on the other. Sorry to be so long.
Thank you. Peter, perhaps you can address, you had made a comment, we were discussing this in advance, that when you're on, for example, an ADR, there may be a tactical reason why you would only want to rely on your expert report vis-a-vis damages and not have your expert be in attendance. So it's somewhat opposite to what the Honorable Mr. O'Brien has said.
Joseph.
Do you have any? Joseph O'Brien. Any comments in that respect?
Well, sure. I strongly agree that particularly in cases involving economic loss of any complexity, that there really should be a substantial and effective expert's report at the mediation, because you do have to cross that threshold of persuasion if you really want to get somewhere. By the same token, I think that part of the dynamic and the effective dynamic of a mediation arises to some extent from the informality of it. And many of you will be aware that in mediations, very large amounts of money can all of a sudden start rolling around for not terribly complex reasons, largely because of informed judgments on the part of the participants. But tactically, it seems to me that one can overdo it in terms of experts at mediations. Part of the dynamic of mediations involves the fact that they are informal and that there is some degree of a poker game. There is some degree of uncertainty. One of the most persuasive things in any mediation is the weighing of risks that goes on. And if one produces one's expert and gives the other side a free throw at a nice thorough cross-examination before there's ever been perhaps even discoveries, or certainly before pretrial or trial, then one may really have given the other side an advantage that one didn't have to. It's a question that involves nice judgment in any particular case. But my general preference is to have a good, strong, effective expert's report that is going to be very credible on its merits, and have that report in at the mediation, and that's it. If there are substantial issues that arise with respect to the damages report in the course of the mediation, then it's a good thing to have the expert on tap so you can answer that and so on and so forth. But my general preference tactically is to leave it at that for the purposes of mediation. There'll be plenty of time later on for further exploration. And in the meantime, in the context of a mediation, one can benefit from that dynamic, that everybody in a mediation is weighing the risks and going to some extent on partial information. And there's an advantage to be gained from that.
One of the issues that Tom addresses in his paper is punitive damages in respect to a professional liability action. And one of the things that may be interesting for plaintiff's counsel to explore in terms of framing the case would be, are you going to try to make a case to set out a factual foundation based on the allegations and breaches that you've put in your claim to establish punitive damages? And the paper seems to indicate that in extraordinary circumstances where there seems to be some very deliberate, intentional, and culpable conduct on the part of the professional, the courts in professional misconduct cases aren't inclined toward punitive damages. Where you see a claim that has been instituted against a professional, let's say it was a lawyer or an accountant, for putting a client in an investment. This seems to be a common thread that comes up in the courts these days. And the allegation is, my lawyer, my accountant did not tell me that he or she personally was going to receive a benefit from my investment. And as a result, had I known, I may have gone and gotten more objective advice because I trusted this particular person who I regarded as my fiduciary. I relied on the evidence and the information and the advice, and I made that investment. So you can, in that type of action, make an allegation for dishonesty, fraudulent misrepresentation. When you do so, when the accountant or lawyer receives the statement of claim, there's an obligation, of course, to report immediately to one's insurer. And the insurer typically has the adjuster meet, and an interview is held, and the basic factual premise of what has transpired is examined. Typically what happens is the adjuster then goes back and writes a report to the insurer to say that here is a claim, there's allegations of dishonesty or fraudulent misrepresentation, and ultimately what comes back in many of these types of cases is a reservation of coverage letter, so that the plaintiff's solicitor, in trying to advocate their client's case to the best extent possible, puts up a roadblock in the plaintiff's own way in the sense of the ultimate recovery, because if at the end of the day that professional is proved to have acted dishonestly, and that's the course and the extent to which the plaintiff's lawyer wants to pursue the case, the plaintiff may find there's no insurance at the end of the day, and the lawyer may not have the sufficient, or accountant, sufficient resources available to make good on the damage award that the plaintiff's been successful in pursuing. So it's something that plaintiff's counsel should be cognizant of, not to say that you don't pursue those types of claims to that extent where the conduct is quite reprehensible, but just something that one should keep in mind in respect to the ultimate recovery of the damage claim. Tom, I wanted to ask of you, we had some discussion about the contributory negligence aspects of these intervening acts, which in professional liability cases seems to be a very artful defense to use to limit and reduce the amount of damages that the defendant ultimately has to pay. And you did make some comments on that. Do you find that there's any particular strategy that's best used in defense to bring out that kind of evidence without, at the same time, given that jury notices are more and more part of these types of claims, without alienating a jury, if pursuing that sort of tactic with the plaintiff?
Yeah, I think that we'll deal with the jury thing in a second. I think to explore those facts, you really need to at an examination for discovery, explore all of the circumstances that the plaintiff was in, and understand everything about the particular investment or decision or enterprise that was in play at the time of the alleged negligence, and then that will allow you, through perhaps the use of an expert, to establish if there is any basis to allege either that the plaintiff himself or herself was contributorily negligent, or whether on the other hand there was some other financial advisor or some other person who might be responsible. I think that juries in these cases do present an added dimension, a different dimension. I don't, speaking for myself, think that that's always bad for the defense. I've never tried a lawyer's case before a jury. I've tried lots of cases for physicians. I think many juries still have a great deal of respect for professionals, perhaps more than trial judges. And you're not always any worse off with a jury, I think. It beats me how an accountant, for instance, would do with a jury. That might actually be a disaster. But I think that juries bring a little bit less cynicism around some of these questions. It'd be interesting to see. I don't know what people's experience is, whether they've seen those professionals tried with juries.
There was one case that may be of interest for you to examine. It's a recent case from the British Columbia Supreme Court. It's Cripps versus Touche Ross. It's actually a case that arose in 1985 but took such a long time to get to court. It wasn't decided till July of 1998, and it's a decision of Justice Lowry, July 10th of 1998 on BC. And in that case, it had to do with investors relying on an audited financial statement that contained what the court found to be a material misrepresentation through negligence. And the defense tactic in that case was to try and establish that the investors were not reasonable in making their investment decision, and that if they had looked at the audited financial statement, that regardless of that, one of two factors, either an intervening factor that the diminution of the real estate value of the underlying investment was the cause, or that the investors hadn't acted reasonably. So the court examined this issue of contributory negligence and determined that there was a known risk. It was stated in the prospectus that if the security underlying the investment, being the real estate, was devalued, their security would be worthless. But the court found that given the number of investors that had taken this investment, it was a reasonable risk to take. Now, whether it sounds like that's a policy decision, the court made that finding of fact, that in the circumstances it was reasonable for these investors, even in the face of that warning in the prospectus, to nevertheless make the investment. So the court held that the accountants were responsible for all of the losses, including the diminution in the value of the real estate, which could be said to have been the cause of the loss. Another case of Hickey and Doan Raymond is a case of the Nova Scotia Supreme Court. That's a 1992 decision, and in that case, they found that the accountants had been negligent in their audited report, but in that particular instance, again, the defense was used of contributory negligence, and what the auditors were pursuing in terms of their defense was factual premise to demonstrate that the plaintiff had in its employ a bank manager who'd been warned that there were not sufficient internal controls, hadn't taken the necessary steps to take remedial measures, and the court, in analyzing that case, held the plaintiff to be 50% contributorily negligent. And that case itself goes through an entire analysis as to what was the actual loss of money. What happened is somebody from the bank withdrew funds, basically misappropriated money from the bank. So there was expert evidence that had been led on what the actual quantification is of what was lost. But then it was a timing issue. So the court starts off at a figure something like 125,000, reduces it to 50, adds on a 15% sway because of the fixed point in time, maybe. They couldn't get a precise number. So it adds it up, and then it subtracts the contributory negligence. So at the end of the day, $125,000 loss turned into a damage award of $24,000 and change, all through the tactic of using intervening acts and contributory negligence. So those types of cases are interesting, and they're very, provide two opposite examples of where the courts will reach out, examine the issue of what plaintiff's conduct contributed to their own loss, and not hold the accountant 100% responsible for the losses in fact incurred. That brings up a point that Peter would like to discuss. There's a Senate Standing Committee recommendation that has been prepared that's intending to have some sort of effect on joint and several liability by now changing the rules to a proportionate liability type of a structure. So could you address that for us, Peter?
Sure. As Tom's paper makes clear, there are many opportunities within the rules of the common law for both the plaintiff to advance the highest damage claim possible, and for the defendant to minimize the damages in various ways. But one other strategy is simply to change the rules entirely. And that sometimes is the subject of debate at the judicial level. For example, in the cases giving rise to the Supreme Court of Canada, a trilogy limiting personal injury damages. More recently, in the libel field, the case of Hill and Scientology in the Supreme Court of Canada, where the defense was unsuccessful in seeking to persuade the court to impose a cap on the damages that could be recovered for libel. And in the field of auditor's liability, there is a very strong movement at the legislative level to change very fundamentally the rules that govern auditors' liability. And as the auditors see it, the main problem is the traditional tort regime of joint and several liability. They see the problem this way. First of all, they say auditors are exposed to claims which often claim amounts sufficient to bankrupt defendant firms. Those actions, secondly, are often brought in cases of business failure, where the only defendant with the assets to satisfy a judgment may be the firm of accountants, which audited the business's financial statements. And under joint and several liability, the auditors, as the last defendant left standing, may be exposed to liability for the entirety of a loss notwithstanding a very limited role in causing the problem in the first place. So this, the auditors say, gives rise to a number of evils. First of all, it makes the risks of defending litigation so high that unjust settlements are entered into. Maybe from some defense perspectives, all settlements are unjust, but the concern is that auditors end up paying amounts in settlement which are entirely unjustified by the merits of the case against them. They also say that, as an empirical matter, insurance availability has reduced by 75% over the last 10 years for auditors. In some cases, deductibles exceed $50 million, with the result being that major accounting firms are basically self-insured. And the cost of insurance, to the extent that it's available, is 10 times what it was about 7 years ago, and it costs about $35,000 a partner. And they generally argue that the current regime gives rise to what they call liability chill. And it may be that these arguments are based on somewhat anecdotal evidence, and it'd be interesting to see what a good cross-examiner could do with them, but they argue that this liability chill makes auditing firms reluctant to extend services into new areas. It impairs their ability to attract the best people. It raises the cost of services, and it's made audit firms reluctant to perform work in areas where their work is most needed. For example, with startup businesses. In those situations, those startup businesses often need an audit report as the key to bank financing. Similarly, in some fields where the business would go into the public markets, a high-tech market, for example, is perceived as being a risky area for auditors. There's a concern that they're not going to get audit services, and that is going to inhibit their ability to enter into the public securities markets, which is vital in that field. So what the auditors want to do is to have the legislatures, and they've been very active at the federal level in this respect, to address the problem by eliminating joint and several liability altogether for actions arising from the issuance of financial information, audit reports being the most obvious example. Now, the auditing profession's concerns are all obviously very serious ones, but it's interesting that it seems to me there's another side to this problem, and as I'll tell you in a minute, there's been progress in the auditor's favor on the governmental front, but it seems to me it's an important public policy issue since it goes to the very fundamentals of civil liability and principles of liability. And whether this is actually going to get anywhere, it seems to me it depends on how much weight one gives to other factors. You know, first of all, for example, it can be argued from the plaintiff's side that as anyone who has done an auditor's negligence case knows, it's not exactly like a wrongful dismissal where the main issue is, okay, let's calculate the damages and get this over with and settle it. These are difficult actions. The common law has been very rigorous in establishing tests that a plaintiff has to satisfy to establish liability and have any recovery at all in this still somewhat novel area within the last 30 years. You know, for example, anyone who's worked in the area knows that the duty of care of an auditor to any particular plaintiff, be it a lending bank or a speculative investor, may simply not be found. There simply may not be the factual connection between that plaintiff and that auditor for there to be any cause of action. And that can result in auditors' cases being summarily dismissed or disposed of through the trial of a preliminary issue. Secondly, there's in any but the clearest of cases, there's often a live issue as to what constitutes negligence or a breach of the standard of care in any particular case. And also, there's the matters of reliance, or in other words, whether this audit report has actually caused the damage in question, or whether, as has been referred to previously, there's been contributory negligence. Whether, for example, in the case of a plaintiff lender whether the plaintiff lender has been adequately cautious and adequately diligent in inquiring into other means of information available to it. And so it seems to me that these principles provide meaningful safeguards for defendants in any event. And they sort of indicate, it seems to me, that there will only be liability in a clear and compelling case, which is likely to involve such a degree of fault that joint and several liability is arguably appropriate. And I also wonder whether proportionate liability would be effective. Because if one puts in a proportionate liability regime, it's not going to help auditors very much if they are indeed, from the outset, the only defendant left standing, because if everyone else is bankrupt, there may be no one else for the auditor to look to reduce their liability in accordance with their fault. In my experience as well, often, although there's always the possibility, I suppose, of third-party proceedings if other potential defendants are not bankrupt, auditors' liability cases are often brought against one defendant. And I guess there's another problem, which is, where does this stop? As lawyers are becoming more and more aware of this program, I'm wondering how the argument is going to be formulated so that we have the benefit of a proportionate liability regime, or whether other professions will make a similar movement. It seems to me that one may well get onto a slippery slope with this side of reform. But in any event, the important thing to know is that there's legislative progress in this area. And at this time, there is a prospect of the federal government enacting legislation as a result of the findings of the Standing Committee on these matters in the Senate, which, thanks in part to very effective advocacy by the Honorable former Justice Esty, of introducing legislation which would provide for a modified proportionate liability regime in the case of financial information issued under federal statutes. It would be even though it affects civil liability, it would be a function of the federal government's corporate law power, or power over financial institutions. And what the federal government may well do as a result of recommendations is introduce a scheme whereby there will indeed be an abolition of joint and several liability for the issuance of financial information. But in the grand Canadian tradition, it's modified by 2 points of compromise. First of all, unsophisticated plaintiffs, and how those are to be defined is another kettle of fish entirely, would be excluded. That is, there would be joint and several liability to plaintiffs who are characterized as being unsophisticated. And the test that is proposed to be applied and which is being worked out is a test used in some U.S. statutes, which goes to the net worth. So we may get into some threshold litigation with respect to these matters. And secondly, joint and several liability would be retained for fraudulent and dishonest conduct. But as I say, the important thing to know is that these things may be coming forward. They can affect very vitally, if they are enacted, the lay of the land as far as professional liability is concerned. And it seems to me that they raise important policy issues, whether one is for or against the initiatives that lawyers concerned with the administration of civil justice should be involved with.
Thank you. Perhaps if there's any questions, otherwise I'll just put one more to Mr. O'Brien. One thing in terms of the perspective from the bench, when we're talking about the issue of contributory negligence, one aspect of Tom's paper deals with the medical malpractice issue and how you would argue that the plaintiff, the patient, somehow contributed to his or her own injury and therefore loss. And how do you, as somebody sitting on the bench, in essence, deal with that issue, and how do you quantify or proportion what their liability would be?
That's a tough question to get into at 4:30 in the afternoon. I think as a trial judge, that's a pretty tough sell, unless there's some very persuasive evidence supporting a contributory negligence against a plaintiff. Not too many trial judges are going to buy that one. And it's going to be very difficult, I think, in many cases to get the kind of medical evidence that would be required to make that kind of persuasion to too many trial judges. You have the odd case where it might be, but as a general rule, I say that it's very unlikely.
Thank you. Were there any questions? Yes.
Just to follow up on that last comment, is it any different if it's a doctor or a lawyer in terms of the contributory negligence?
I think probably there is, and probably there shouldn't be. There's something about a malpractice case where I think a lot of judges tend to be much more sympathetic to a bad medical result than they do to a bad financial result, which usually involves the lawyer. And I can't be more articulate than that about it, but I think there is a feeling that, particularly in a lot of medical malpractice cases, a lot of plaintiffs are not probably compensated because of the problems in causation. And I think judges generally are much more sympathetic in the malpractice case than they are than the case involving a lawyer. That's just a horseback. I have no statistical basis to make it.
Thank you. Any other questions? Well, I'm sure you've had more than a long day. I hope that you've all learned something here today, and thank you very much.